Good morning, San Diego. My name is Bella Pernetta. Today is June 25th, 2014, and the Riley versus California case has been decided. Police officials arrested David Leon Riley on August 22nd, 2009 for using expired plates on his car. However, during the inspection of the vehicle, 2 loaded guns were found in the hood of the car. Let's jump on over to the crime scene with Leah Codwell.
When he was pulled over in San Diego. As Bella said, 2 guns were found in the hood of the car, so police began to arrest him. An officer then noticed some suspicious cell phone activity as he recognized some gang references. Riley's cell phone was inspected without a warrant by a gang analyzer. Photographs of Riley making gang signs and other gang insignia were proof of his involvement in a shooting on August 2nd, 2009. Back to you, Bella.
Before Riley's trial, he tried to move to suppress the evidence on his cell phone based on the Fourth Amendment. But the San Diego trial court denied the motion, justifying it with the search incident to arrest exception. This exception permits the police to conduct a full search of a cell phone when it is found near the suspect at the time of the arrest. The gang expert testified to prove Riley's involvement. Riley was convicted, and the court moved on to the California Court of Appeal, 4th District, Division 1. The California Court of Appeal affirmed the trial court's decision based off of a prior decision in the People v. Diaz case. But enough people petitioned so that the Supreme Court granted a writ of certiorari, which lowers an order court to deliver the case to the higher court so that the higher court may review it. The case was then docketed on July 31st, 2013, and given the docket number 13132. This docket contains all the public records concerning the case.
I'm now at the Supreme Court in Washington, D.C. I'm going to speak to the Chief Justice, John G. Roberts, regarding the court's decision. There has been a previous decision in People v. Diaz case to give police officers access to an arrestee's cell phone when it is at the scene at the time of arrest. So in this oral argument, or time when speakers argue and try to show the judges why they should prevail, what is being argued with the search incident to arrest exception?
Well, the search incident to arrest exception aids the government in 2 ways. First, the police must search the area to ensure officer safety. Secondly, it is important to search the scene of arrest to ensure that no evidence is destroyed. However, in this case, Riley's attorneys argued that since the source of evidence was a cell phone, the exception does not apply.
So what does this mean for
The
Riley?
search incident to arrest exception does not apply when there is no possibility that the suspect could gain access to a weapon or destroy evidence. During the oral argument, Jeffrey Fisher spoke on Riley's behalf and argued that the search was not justified for 2 reasons. First, a cell phone itself does not threaten officer safety. And secondly, searching it after its seizure was not necessary to prevent the destruction of evidence, considering the technology available to the police. He argued that the search was unreasonably intrusive.
And Edward Dumont was responsible for arguing on the behalf of the respondent, the state of California. What did he have to say in his oral argument?
The main argument was that cell phones should be treated like physical evidence if they are at the crime scene at the time of the arrest. He argued that carrying potential evidence has consequences regardless of whether it is digital or physical.
Michael Dreeben played a big part in the oral argument. What was his
The
role?
amicus curiae supporting the respondent. This means that he was an impartial advisor. An amicus curiae is responsible for bringing the court's attention a relevant matter not already brought up by either Fisher or Dumont in this case, in order to protect the court.
Finally, we're all dying to know. What was the court's rule?
Yes. The opinion of the court, our official decision, was that a warrantless cell phone search violates the Fourth Amendment to privacy.
Thank you, Chief Justice
In
Roberts.
addition to reversing the California Court of Appeals decision, the Supreme Court also affirmed the First Circuit in the United States versus Worry decision. This was a similar case where police found cell phone evidence without a warrant. Brema Worry moved to suppress the evidence on his cell phone, but like Riley, his motion was denied. Only this time, the First Circuit Court reversed the denial of his motion. Now back to Leah, who
The
stated...
court voted unanimously on the case, and there was no minority decision, which is an opinion by one or more judges who completely disagree with the court's official decision. However, Justice Samuel A. Alito Jr. had a dissenting vote in the decision, which means, although he agreed with the decision, he had a different reasoning. Good afternoon, Justice Alito. Can you explain to me what your doubts were in the Riley versus California? I believe that it was reasonable to search a cell phone only for the purpose of protecting officer safety and preservation of evidence. In the case, I suggested that the legislature dictate laws that are specific to the search of a cell phone following an arrest. However, I agreed with the collective mindset that the court's decision...
Thank you, Justice Alito.
There you have it. The court's decision is a huge victory for privacy advocates and expresses the court's willingness to sacrifice in order to uphold the Fourth Amendment. However, critics say that the ruling leads to less safety for citizens, even if it protects privacy. They argue that when there are serious safety threats, it is dangerous to wait for a warrant, and that warrantless cell phone searches are necessary to protect the public against criminals. This is a landmark case because it concerns the privacy rights given to citizens by the Constitution. Jeffrey Fisher, Riley's lawyer, said, "The decision brings the Fourth Amendment into the 21st century. The core of the decision is that the digital information is different. It triggers privacy concerns far more profound than ordinary physical objects. This decision can affect future cases. For example, in August 2015, a case was argued before the New Jersey Supreme Court and the Fifth Circuit Court of Appeals after evidence was found using location data of a cell phone. They defended that the Fourth Amendment protects an individual's location privacy and used the court's decisions in Riley versus California to prove the constitutionality. That's all we have time for today, folks. Thanks for tuning in.